Wilson case started in 2009 when Joe Wilson, who was a supervisor of procurement at AECL, was terminated. Mr. Wilson believed that he was terminated in connection with his having complained about corruption in the procurement division at AECL. And he filed an unjust dismissal complaint and proceeded to the Canada Labour Board. And Atomic Energy of Canada Limited took the position that when they terminated him without cause and paid him a notice amount. And they took the position that was sufficient in terms of their obligations to Mr. Wilson. The matter went to a hearing. At the hearing, AECL took the position that their termination without cause was in compliance with the Canada Labour Code and brought it as a preliminary motion. At the preliminary motion, the adjudicator, Stan Schiff, determined that in following the 38 years of law, that an employer could not terminate an employee, particularly Mr. Wilson in this case, on a without cause basis, and that his termination in fact was unjust.
I became involved working with James LeNoury in the summer of 2011. I became involved with Mr. Wilson's case in the summer of 2012 before I went to law school. I attended the adjudication hearing with Professor Stanley Schiff in the summer before I started, and then I was involved throughout the case throughout my 3 years at Western Law. I worked on the Federal Court Judicial Review, I worked at the Federal Court of Appeal, and assisted James at the Supreme Court of Canada as well. The significance for me about this case was that I started on this file in September of 2012 before I started law school at the first hearing with Mr. Wilson, and then worked on this file throughout law school, years 1, 2, and 3. And at the completion of law school, when the Supreme Court of Canada decision came out, we're returning back to adjudication. I'm now a lawyer with Dunsmore Waring, and Mr. Wilson doesn't have a resolution for his case.
We took the case in the manner that we did in terms of the appeal process because there was 40 years of law that adjudicators, scholars, we believe the intention of Parliament when the unjust dismissal legislation was introduced in 1978 was that federal employees who are non-managerial could only be terminated on a with cause basis. During the 40 years, there were only a small number of decisions that took the position that AECL did, that an employer could, in fact, under the provisions of the code, the language of the code, terminate an employer on a without cause basis.
Working with Mr. LeNoury was a great opportunity. I think the team worked very well. It was Mr. LeNoury, Mr. Serlin, and myself who went to the Supreme Court and appeared before the 9 justices of the court on this important matter. I think it was a really good collaborative team effort. There was really good synergy. Each lawyer had their own views, their own words that they wanted to use, but eventually we got a common theme and a common thrust, and I think the results speak for themselves. It all worked out very well.
For a lawyer, it was an honor to appear at the Supreme Court. The hearing itself, it certainly has an impact on, it certainly had an impact on me as a lawyer when the doors opened at the beginning of the hearing and the 9 judges came in and took their seats on the bench. The hearing itself, the fact that you're dealing with 9 very bright people, the leading jurists in our country, and they're asking you questions about your case, was also an interesting and privilege to take part of as a lawyer. That's where you begin that training in law school in terms of dealing with appeals and appearing before courts and answering questions, and to appear at the Supreme Court and be faced with questions from the 9 judges of the Supreme Court is just an experience that for any lawyer is a highlight in terms of their career.
The kind of determination that it took for him to do this Wilson case to the Supreme Court is awe-inspiring. It took years and years that he stuck with it, and it was a very difficult process. And it just goes to his courage and his determination that he decided to make this something that he would carry through right till the end. And we're just really proud of him. He got the result that he deserved. And mostly I think it's because he is the type of lawyer who really wants to do the best that he can for his clients at all times.
Working with James and with the lawyers at Dunsmore Waring is fantastic. What we have really created here is some kind of a confederation of experienced labor and employment law practitioners. We work together for the benefit of our individual clients, but we have the looser association so that we can each pursue our individual business goals and our individual practice goals. When we need to, we can bring together the resources that we have collectively, but we don't necessarily incur the same structural slowness or costs that sometimes arise with a partnership or a larger firm. So we try to bring the benefit of both to our clients.
For employers and for employees, the outcome of the decision is that we now have finality with respect to how the interpretation of the unjust dismissal provisions will be applied. And that is as it was intended by Parliament when the legislation was introduced, that the legislation would be similar to the entitlements that employees have under collective agreements, and that is that in regard to dismissal, that an employer can only terminate an employee with a just cause standard.